land lease contracts. And if you've been looking for one, I'm going to put an example of a land lease contract right here in the description below. It's a link. You can click on it, copy and paste the entire thing into your own document. And of course, you can make edits however you like to. I will say that before you actually use this, I would highly recommend going and finding a local real estate attorney that can look over your edited version and make sure everything is buttoned up the way it needs to be. You definitely want to do that before you sign up for 10, 20, 30 years of paying someone hundreds or thousands of dollars per month. So anyway, with that being said, we're actually going to go through the entire contract right now because it's not just good enough to have one. You also have to know what it says, and you have to understand what it says, because it's very common for landowners to call you up and say, hey, what about, page 3, section 4A, it says this and this and this. Can we change that to say this? Or what does that even mean? And if you don't know what it means, then he's going to look at you like, what are you even doing? You're the one that gave me the contract. How do you not even know what this is saying? So you really need to know it inside and out. Starts off with Billboard Development and Lease Agreement. This lease agreement is dated effective as of blank date 2024, by and between blank, a Virginia corporation. So that would be the landlord. And then you'd put your name or your LLC in the next blank. I've got this one adjusted to me, so it's a Virginia corporation. Paragraph number 1 says, landlord hereby leases to tenant 150 by 50 section of real estate commonly known as blank. So that would be the street name and street number there, parcel IDs, and the next blank is situated in the city or the county of blank, and then your state. Such property tax number and legal description being attached hereto and incorporated herein by reference as Exhibit A, the property. The property is leased to tenant for the purpose of erecting, maintaining, operating, improving, supplementing, posting, eliminating, repairing, repositioning, and or removing an outdoor advertising structure, whether physically painted, printed with vinyl or similar material, digital or otherwise, including without limitation, fixture connections, electrical, solar panels, static signs, copy, and any other equipment or accessories as tenant may place thereon, collectively the structure. So certainly that should cover just about anything you could possibly put on the structure. Paragraph number 2. Unless terminated earlier in accordance with this lease shall be in effect for an initial term of 360 months or 30 years. Now, this is adjustable, obviously. I wouldn't go anything lower than 10 years, a minimum of 10 years, because obviously you want to have enough time to get your money back, your initial ROI, and then you want to have some time to make some money off of it. And absolute worst case, if they did a 10-year deal, and they made you take it down, obviously that would be bad, but you want enough time to actually make it worth your while. If that is the case, though, if you have somebody that says, I'm absolutely only going to do a 10-year term, I think that's in most cases, because, well, they think they'll have a good reason to renegotiate the deal to a lot higher rate after 10 years. But then also, they might say, well, there might be a big development or something coming in. I might not want this billboard here after 10 years. So if that was to happen and it was a really good spot and you didn't want to just let it go, you could do a 10-year agreement that automatically renews for an additional 10 years and even an additional 10 years after that. So you can start out with 30 years. And if they say, no, I'm only going to do 10, then, have it automatically renew for another 10 and then another 10. So basically, if a big development does come in and they want to, they don't want to renew, or for whatever reason they don't want to renew, then technically they don't have to. But you're kind of banking on 10 years going absolutely fine. They not even remembering that they have the chance to cancel it after 10 years, and the thing just automatically renews. So what I'd say is, hey, if everybody's happy, it renews for another 10 years. And if automatically, you don't want to have to call them up and do this, especially not if you have a lot of locations and you have to try to remember that. But, if for some reason you're not happy or something's going on, then, you don't have to renew. So that's kind of how I've got this one structured, even for a 30-year lease. So starting on the commencement date of the lease. So the commencement date is a important date, and we'll get into that in just a second. But the commencement date will occur on the first day when all government permits and approvals have been obtained and the structure referenced by Exhibit A has been fully installed and advertisements have been posted. Okay, so that is the commencement date. So the way I've got this written is the date that it's signed. You don't want to have to start paying monthly land rent on the date this contract is signed. You want to delay that monthly rent until the billboard is built and you have an ad posted on it. Some people are going to say, well, I want my money the day this thing is signed. And I've always said, well, I don't have any money to give you until I have money coming in. So I have to sell ads to have money coming in so I can pay you rent. And on the first day, I don't even have a sign out there. So I don't have any money to give you yet. Sometimes that works, sometimes it don't. But anyway, it's actually worked a lot. So I've had pretty good success with that. But anyway, this lease agreement shall carry one 30-year optional term that shall automatically renew unless written notice is given to either party 12 months prior to the end of the current term. So they can't wait, the day before the end of the current term to cancel the next 10-year period. I need to know 12 months before the end of the current 10-year period so I can make plans to come in there and remove the structure and everything. Any holding over by tenant after the expiration of the lease term will not constitute a renewal of the lease, but will be on a month-to-month basis on the same terms and conditions as applied in the lease term. Okay. Paragraph number 3. The tenant shall pay landlord rent in an amount equal to blank dollars per month. Monthly rent payments may be processed via electronic payment, ACH direct deposit. You definitely want to have that in there. I had a guy one time, he was an old school guy. He wanted a paper check every month. He did not want direct deposit. Well, that's fine if you only have a handful of billboards, but if you got a few thousand billboards, you can't be writing paper checks every month. That just does not scale out. So, thankfully, my bank, I had everybody else on regular direct deposit, and thankfully, my bank would actually mail this guy a check every month, and they didn't even charge me any extra for it. But it was an automatic check. I had to set that thing up to be processed on like the 16th of the month for the next month because they had to process it. Then they had to mail it out, and it had to get to him. And sometimes the post office was ultra slow. So anyway, it worked out fine. There was never any problems, but sometimes you have that in there. Anyway. If everybody would just do ACH direct deposit, it'd be a lot easier. The first such monthly installment being prorated for the initial month and all payments thereafter due and payable on or about the first business day of each calendar month during the term. Tenant is and shall remain the owner of the structure. Tenant has a right to remove the structure at any time until tenant no longer has any rights to use or possess the property, whether 1, under this lease or an extension, renewal, or modification of the lease, or 2, by operation of law, as a holder over tenant, condemnation, or extinguishing of any such right that otherwise is held by the tenant. Tenant must remove the structure within 120 days of termination of this lease. If the structure is removed for any reason, only the above ground portions of the structure need to be removed. When you build structure, specifically a steel monopole structure, or you can do it with I-beam structure too, you want to bore your hole extra 3 or 4 inches down and then leave the concrete 3 or 4 inches below the surface of the ground so that if you ever did have to remove this, hopefully you don't, but if you do, you can come in there with a cutting torch and just cut out 3 or 4 inches below the surface of the ground and just remove the above ground portion of the structure. take it somewhere else, put in a new column pipe on the bottom, and just move it. And then fill in the existing pole, the center of it, with dirt, and that's that. So you don't want to have to, especially if you get a tall one, you're going to be down there 15, 20 feet down. You're not going to want to dig all that foundation up. So that's a good part to have in there. Tenant has the sole right to make any necessary applications with and obtain permits from governmental entities for the construction, use, maintenance, and removal of the structure. So you want to be able to do all your permitting and everything without having to get any additional signatures or anything from your landowner. This lease should be enough to get your state permits and stuff. You should be able to say that you have a lease on file. Landlord shall not prevent the removal of the structure by the tenant. So, yep, that's right. Landlord and landlord's tenants, agents, employees, clients, or other persons acting on landlord's behalf shall not place or maintain any object on the property or any neighboring real property owned or controlled by the landlord which, in tenant's sole opinion, would obstruct the view of the advertising copy or display of the structure. So, this is primarily geared towards trees and brush and greenery and stuff like that. But you will have the occasional 4th of July firework tent pop up, which is what happened to me one time. Had a structure that was near a parking lot, and for some reason they decided to, I guess, lease out the part next to the billboard of the parking lot to one of these people that are selling 4th of July fireworks, and they had this big old carnival tent there. Well, that's fine, but it can't block the view of the billboard. So it's all kinds of crazy stuff I never would have thought that would have happened, but stuff happens. Landlord has a total of 24 hours after a voice call, written, or email notice from tenant to remove any such obstruction that in a tenant's sole opinion is obstructing the view of the advertisements. Tenant may remove or trim any trees or vegetation currently on the property and own any adjacent property owned or controlled by the landlord as often as the tenant in its sole discretion deems appropriate to prevent obstructions. Without limiting the foregoing, landlord shall not permit the property or any neighboring or adjacent property owned or controlled by landlord to be used for the advertising of off-premise services, products, or commodities. So if the landlord owns a long piece of road frontage, and like where I'm at, you can have billboards every 500 feet if the zone is right, and there's not any other billboards there. Let's say he's got 1,000 feet of road frontage, and you build on one corner of it, then technically he could go down and lease another 500 feet to Lamar if you're not interested in building two there for whatever reason. So you'd prefer that not to happen. So it'd be a good thing to have that in there. All such permits and rights to outdoor advertising on the property or adjacent property owned or controlled by a landlord shall remain the property of the tenant. If, in the tenant's opinion, the view of the structure advertising copy becomes entirely or partially obstructed from normal highway view, electrical service is unavailable, the property cannot safely be used for the erection or maintenance of the structure for any reason, the property becomes unsightly, there is a diversion, reduction, or change in directional flow of traffic from the street or streets currently adjacent to or leading to the property, the location's value for advertising purposes, demand for advertisements is diminished, if the structure of the property or any part thereof is condemned by proper authorities or taken without the existence or exercise of eminent domain, whether permanently or temporarily, if any right of way from which the structure is visible is relocated, or if the structure's use is prevented or otherwise restricted, the tenant shall have the right to terminate this lease upon not less than 30 days written notice to the landlord. So this is the tenant's out section right here. You don't want to have to use this, but if everything were to hit the fan and for whatever reason the location's value for advertising purposes is diminished, then this does give you the right to cancel the lease. Like I said, hopefully that doesn't happen. The landlord really does not have a way out. Once he signs this deal, unless you default, on your obligations, which is mostly just paying the rent, the landlord doesn't really have a way out. So, which that's the way you like it, because you're going to invest a lot of money building something on someone else's property. You don't want them to cancel on you. Let's see. Tenant shall have the right to terminate his lease upon not less than 30 days written notice to the landlord. Tenant shall be entitled to all compensation and other remedies provided by law, including without limitation just compensation for the taking of the structure and tenant's leasehold interest in the lease. Limitation on this use or maintenance of the structure, loss of goodwill, and or relocation assistance. Landlord shall assert no rights in such interest. So this is if you have eminent domain come in and take your structure. So if it's on a 2-lane road and all of a sudden they go in and they move it to a 4-lane road with a sidewalk or something, then there's no place to move your structure, then I guess the government would cut you a check for the value of your structure and the interest in the lease. But obviously you wouldn't want to have to divide that up with the landowner. So it'd be good to have that in there. If condemnation proceedings are initiated, landlord shall use its best efforts to include tenant as a party thereto. No right of termination set forth in this lease may be exercised prior to the sale to any entity with the power of eminent domain or for the benefit of any entity with the power of eminent domain. Landlord represents that it is the owner or owner's authorized agent of the property and has the authority to enter into this lease. Tenant is responsible for securing all necessary utilities for operation of the structure. Landlord shall provide tenant reasonable and readily accessible access over, across, under the property for tenant to enter and exit the property for installation, maintenance, and removal of the structure, including without limitation from or through adjoining property owned or controlled by the landlord. See Exhibit A for the description of access to the property. So Exhibit A is going to be down here. I would just put like an arrow coming in this way right here, and then that'd be how I'd get to the property. So even just last week, I was going to do some maintenance on a billboard, and the landlord lives across the entrance way to the billboard, and he comes out there and it's like, whoa, you can't go out here because it's been raining so much. You might mess up our grass. And, I was just going to swap out some cameras, so it wasn't anything super urgent. But, the lease does not say, hey, if we might mess up your grass, we can't access the billboard. If the billboard is down and we've got 16 people paying us every month for their ads to be up there, and we're still paying him rent, then we gotta figure out a way to get to this billboard to fix it. So, you definitely want to have that you have access under, through, above the property in all those cases. So you don't want to have any limitations getting to your structure. If the property is currently encumbered by a deed of trust or mortgage, ground lease, or other similar incumbents, landlord shall deliver to tenant not more than 90 days after the effective date of this lease agreement hereof a non-disturbance and attornment agreement in a form reasonably acceptable to the tenant. In the event tenant defaults in the performance of this obligations hereunder or breaches his lease, any and such breach or default is not cured by the tenant within 90 days, and landlord delivers written notice of such default or breach to tenant, landlord shall have the right to terminate this lease and pursue any and all rights it may have against tenant. So that's the only way the landlord can cancel this lease. Landlord shall indemnify and hold tenant harmless for any and all actions, damages, costs, claims, losses, fees, awards, judgments, fines, penalties, expenses, including attorney fees, resulting from or arising out of the acts or omissions of the landlord's employees, agents, clients, licensees, and contractors, except where due to the negligence and willful acts or omissions of the tenant. So that's the landlord indemnifying. Once the landlord's attorney reads over this, they're probably going to want the tenant to also indemnify. So either that or you're probably going to take that out. One or the other, in most cases. This lease is binding upon the heirs, assigns, and successors of both landlord and tenant. So out of the whole lease, this right here is a very, very important sentence right here, because this allows you to assign the lease contract to another person. If you are just getting started and you don't have the money to build a billboard, you could just take this document, go out there and lease the property, or your money's not actually going to start flowing. You're not going to actually start paying for the land until the sign is built. So it doesn't really cost anything. Just go out there and find the right property, talk to the landowner, get them to sign up for this. And then you could technically sell just this contract to a billboard company, and you would assign it to them. Like this paragraph's talking about, preferably without the prior written permission of the landlord. That complicates things when you have to do that. But if you can assign this contract to another company, whether they buy your entire operation or they just buy this lease or just one billboard with this lease, you definitely want to have the right to assign the contract. If landlord does wish to sell the property, landlord shall notify tenant, and tenant shall have the first right of refusal. So I just put that in there, not necessarily because I was interested in buying the property, mostly just because the properties that the digital boards are owned, they're so expensive. It doesn't really make sense for the billboard company to spend that much money on the property unless it's something else you can do with it. But I put it in there just so I can have an idea of what's going on with the property. You want to, if the landlord is going to sell the property, it's better to know about it ahead of time versus on the backside. If the property is not purchased by the tenant, landlord agrees to notify the tenant in writing of any change of ownership of the property or any portion thereof, and not to assign this lease to any competitor of the tenant without tenant's prior written permission. So you definitely don't want your landlord to sell their property to Lamar or somewhere like that, because they are for sure not going to renew your lease if they buy the land. Tenant shall have the right to assign, license, or sublet this lease, the structure, or any portion thereof. So yeah, if you want to have a management company manage your billboard, you just get it built. You want to have the right to do that as well. So that way you wouldn't really have to do any of the day-to-day. Management company would sell the ads, do the artwork, post the ads, whole 9 yards, collect the rent, and then collect the income from the ads, and then just pay you a portion of that every month. Any notice to any party here too. So that's just who is responsible for any notices. And then this next section is just about if there are any issues where you have to go to court over the contract, you want to make sure that you use a local court in your county or city close to you, and it's not way off somewhere that you'd have to travel to. You wouldn't want that. So just sign and notarize, and then you're all good to go. I usually put like a bird's eye picture of the GIS showing the boundary lines, and then the 50 by 50 box around the sign or where the sign would be built at. This one needs to be scooted over a little bit. It needs to be right on the property line, but then you can put a description of the message faces, 10 by 22 digital LED message faces, and then a picture of the sign. Obviously, this is after it's built, but it's just been updated. So that's about all it is to it. Like I said, you can copy this and adjust it to your exact scenario. And I would for sure have a local real estate attorney, someone that is well-versed in land lease contracts, look over this and make sure there aren't any loose ends that could potentially get you in trouble down the road. So anyway, hope this helps, and feel free to leave any questions in the comments, and we'll be happy to help. Thanks.